Good afternoon. My name is Nicole Moss, and I'm the Secretary and a member of the Board of Directors for the Association of Corporate Counsel Houston Chapter. On behalf of ACC Houston and the Texas Lawbook, welcome and thank you for joining us for this presentation of the bankruptcy pandemic, co-hosted by the Texas Lawbook and sponsored by Weil, Gotshal and Manges. If you are not yet a member of ACC Houston, we encourage you to join 1,100 other Houston area in-house attorneys who already enjoy access to an incredible flow of CLE content like today's presentation. And today's presentation will be available on our website in our webinar library starting tomorrow. We have some excellent upcoming events at ACC Houston in August. Among them our symposium, one of our signature events, which will follow an all-new virtual format this year. And I'd like to invite you to look at our website for additional information or to register. Registration will be open tomorrow, and also there's no charge this year for attendance. In addition, we are wrapping up plans for our Texas Lawbook ACC Houston Corporate Counsel Awards, postponed from April, but not canceled. We'll be in touch with you all about that in the coming weeks. Finally, if you're not subscribed already to the Texas Lawbook, we encourage you to check them out. ACC Houston members are invited to try them out for a free one-year subscription, which you can claim by getting in touch with them at texaslawbook.net. Personally, I read it daily. It's a great publication with helpful, relevant, and very timely content. We are very grateful to Texas Lawbook for co-hosting and to Weil for sponsoring this event, and to our exceptional panelists who you will meet shortly. We're in for an excellent event today. And now for further introductions and to get started, I'd like to hand off to Mark Curridon. Mark is the founder, senior editor, and writer for the Texas Lawbook. And Mark, I'll let you take it from here.
Thank you so much, Nicole. We really appreciate it. And we love our partnership with ACC Houston. As Nicole said, if you're not a member, you really need to become a member. They've got so many great programs. We're just thrilled to be a partner with them. I also want to take a few minutes to thank not only Nicole, who we work with regularly, but Elena. She has been great. She's the executive director. They just do such an amazing job. So the membership is well worth the price. Like you said, Nicole said, you get a free one-year subscription to the Lawbook, and then you get to attend all of our CLE programs for free as an ACC Houston member. So really appreciate that. Also want to thank Brooks Igo. He's our publisher for helping put this together. And then also, about to introduce the panelist here in a minute, but I'd like to thank Alfredo Perez, partner at Weil, Gotshal, for sponsoring this event. As Nicole said, we're also going to be having the Houston Corporate Counsel Awards. And one of the great things about the awards that we do with ACC Houston is we write a profile, an in-depth profile of all the winners. And we've already started those interviews, and we'll be publishing those starting in about 3 weeks. And there'll be in-depth profiles of all 13 winners. And we've got some great winners this year, and you can read about them on the website. Few other quick things. We've got some great Lawbook projects that we've been working on. Alan Pusey, actually one of our senior editors and writers, just had a great profile of Jared Sine. He's the general counsel of Match.com. And while the rest of us have been homebound for the last 5 months, Jared actually did a $30 billion spinoff that he finished during the last 5 months. And then he settled a major case with Bumble, a competitor, in the Western District of Texas. So we have a lot of great stuff going on. And then finally, we have a profile of the chief judge of the Southern District of Texas, the chief bankruptcy judge, David Jones. And Judge Jones, you'll be hearing a lot more about him, especially from Victoria Lazar and from Alfredo in just a few minutes. Let's go ahead and start introducing the panel here. Let's start with, now what I want to do is I'll start with Alfredo. I want to kind of go to Alfredo first, but before we do that, Brooks, will you call up the two charts that we have? These are some exclusive data charts from the Texas Lawbook that we have. The first is this chart right here. We, about a year ago, hired a great researcher named McKenna Brooks. And McKenna has been tracking every business bankruptcy that a Texas law firm is involved in. Those both being business bankruptcies in Texas, And even when a Texas lawyers, for example, Alfredo has bankruptcy restructuring cases all over the country. And we've been following each and every one of them. And we're going to have several new data charts that are going to appear over the next 2 or 3 weeks. And one of them is a chart that tells you every business bankruptcy that's been filed so far this year, who the law firms are involved, where it's filed, and what role the law firms and the financial advisors play. To give you a little tease, there on the screen, you see the list of the top dozen that McKenna has put together. Now, these have to be lawyers in Texas, in the Texas offices of law firms that are working on bankruptcies. A couple of interesting trends, and we can actually have Alfredo talk a little bit about this in a minute, but Jackson Walker is number 1, Forshey Prostock is 2, Kirkland and Ellis, Haynes and Boone, you see down the list. What we see happening a lot in Texas is law firms teaming up. While Godshaw teams up with some lawyers, some firms, Kirkland and Ellis teams up with some, and so forth. But right there you have the list of the law firms and lawyers in Texas that are involved in the most corporate bankruptcies and working on them, whether they're as the debtor, working for the debtors, as debtors counsel, for creditors, or for special counsel, landlords, etc. Brooks, go to the next screen. The next screen here is actually the bankruptcy trends from the first 6 months of this year and tracking back 6 months all the way back to 2008. And what you'll notice is Chapter 11 business bankruptcies are way up in Texas. The Northern District had a significant increase, but the Southern District by far is the story. And the Southern District has just seen a huge jump in the number of business bankruptcies. You can take a look at that data for a minute. Of course, Delaware is where so many business bankruptcies are filed because so many companies are incorporated there. And then, of course, the Southern District of New York is the third most popular district. Tell you what, let's go to Alfredo first. Alfredo, kind of walk me through any surprises in any of these numbers, and what are you seeing just out there in the, are we near the peak of where we're going to be, or are we going to see a whole lot more Chapter 11?
Well, first of all, Mark, thanks for inviting me to join this panel with such a distinguished group. Some people that I've known for a long time and other people who I'm just meeting. But I really do think that the bankruptcy, the pace of the bankruptcies that existed prior to the pandemic was pretty frothy. I mean, there was a significant amount of restructuring. You had, all of the dislocation in the oil and gas industry that had occurred even prior to the pandemic and prior to, frankly, the clash between the Saudis and the Russians, which prompted, in some respects, a spike down in the price of oil. In addition to that, you had your traditional businesses that had, challenged business models like the retailers, some of the restaurants. But I do think that the pandemic has really exacerbated things in 3 different ways. Number one, I think that, some companies that had wonderful business plans as a result of the fact that people have just been sitting at home and not spending money has really created issues. Prime example of that, unfortunately, are the airlines, which, and some of the entertainment venues. Those kind of fall in that category. So that's kind of the, good company, good business plan, people just stop spending money. So that's one. 2, I think that the companies who were otherwise challenged and perhaps had an okay business plan and had an okay business, but were over-levered, I think those are also going to come to the forefront because there is really no ability to to do things now that might have existed even a year or 2 years ago with respect to a company that was over-levered. And then three, and frankly, a lot where you see the oil and gas companies is there's just really no capital or very little capital that people are willing to invest. So to the extent that a company needs capital in order to recapitalize, to reorganize, the capital, frankly, just doesn't exist. So I guess, good business affected directly by the pandemic, a business that is otherwise good but challenged because of their capital structure, that's an issue. And then, finally, businesses that really need capital are going to have problems. And kind of the areas that you see most directly are, obviously entertainment, retail, hospitality, and the oil and gas continues to be it. I mean, I haven't pretty much left my house since March 16. I put in a tank of gas probably first week in March, and I'm still not down to half a tank yet, just from the very limited amount. So it's like used to be 20 miles per gallon. Now it's half a tank every 3 months. So.
Are there other industries that we went through this period of what we called pretend and extend, and that was where the banks kept loaning more and more money, or at least forgiving and looking the other way. Are we still in that kind of time period, or are we really starting to see where they're going to have to, where banks are going to have to start foreclosing, whether it's in commercial real estate or calling on the debt, on the debts that they have out?
So the whole premise of kind of the pretend and extend is that you had a viable business that was otherwise cash flowing, but that were just basically over-levered, and you just wanted to push things out. I think fundamentally what you're seeing is that companies are running out of money, and it's not so much you can't pretend and extend when a company, just because their demand has dried up, or because they have way too much built-in cost. You really cannot, in my view, pretend and extend when fundamentally there's no cash flow there in order to be able to sustain the company during that business. I think that's what you're seeing, where unfortunately many companies just don't have the financial flexibility or the liquidity to be able to say, okay, we'll extend maturity for a year, and we'll keep going, hoping there's a rebound. They don't have, they need hundreds of millions of dollars to get there, and that's kind of the problem.
Before we move on, a lot of Chapter 11s have been filed, but the courts aren't really having hearings in person. First, how many courts are you cases in? Are you involved in it, and how's it playing out? Is it all via Zoom, or is it working?
So I would say that there's no question in my mind that the Southern District of Texas has kind of led the technology boom. I think that they really got on the technology boom, bandwagon long before many other courts did, and so we've had basically virtual hearings since mid-March. Including filing new cases. We had a 6-day trial with multiple witnesses, all done remotely. So I think that in terms of the technology, it's worked out well. And they use something similar to Zoom. I think it's called GoToMeeting. Delaware uses Zoom. I think that's worked out fairly well. There are still some courts that will just do it telephonically without a video component. And then I just appeared in a case in the Eastern District, which sits in Central Islip. But we actually, every time we had a physical hearing, it was in Brooklyn, because it was the Brooklyn courthouse. But they did kind of a mixed. They had some people on by video on WebEx, and then they had the other people on telephonically if you didn't have to appear. But I think it's worked well. I don't, people complain, oh, I can't get my exhibit up and things like that. But I think the kinks are starting to come out of the system. It may take a little longer, but I'm sure you will hear from others. I mean, it takes a lot of the inefficiency out of the system, because literally, you don't have to travel to court. You don't have to wait around. You're there, you have your hearing and you hang up the phone and you're done. I think the big limitation on all of these, on having hearings in the bankruptcy court remotely or anywhere for that matter, is the ability to record them, because you need to be able to record things in order to have an appellate record. And that's, in my mind, the biggest limitation. And to the extent that, there's more sophisticated technology with respect to recording, there's going to be more demand for this. I just don't think we're ever going to, I can't see myself, taking a 2-day trip to Delaware for a 30-minute hearing anymore, which I used to do routinely.
And on these calls or Zooms, there's dozens and dozens, or sometimes even hundreds of people involved, right? Legal, financial advisors, company officials, et cetera.
Yes. The J.C. Penney first day hearings were on a Saturday, and I guess it was well publicized, and I think there were probably close to 500 people on the call, including many former J.C. Penney employees. So it was a huge event, kind of on a Saturday morning.
Victoria Lazar, let me bring in Victoria. Victoria is a rock star in the world of M&A, but she got thrust into the world of corporate restructuring. Victoria was at GE, General Electric, in the leading M&A for the legal department, and did the Baker Hughes M&A deal, and then moved over to Bristow. Victoria, kind of walk me through, what was your just whole experience? Because you just came out of bankruptcy, and then you did an M&A deal coming right out of bankruptcy.
So first, let me say thank you also. I'm very pleased to be on this panel and contribute what I can. So I would describe bankruptcy from the debtor's perspective. I saw it a little bit at GE and some at EDS from the creditor perspective, but more from the debtor perspective, as M&A with litigation piled on top of it. So you have a lot of competing interests, careful negotiations, but then a slightly chaotic and aggressive aspect to it, where people are really trying to defend their rights, as they should be, and trying to come out with a plan. So you have this tension between wanting to confirm a plan, which requires the majority to sort of agree, and then making sure the minority rights are taken care of. So it's not unlike, in my mind, to use a offbeat analogy, Congress. You've got the rights of both the majority and the minority are protected, and everybody needs to be satisfied, at least from the debtor perspective. So I found that my business background in change of control type transactions was useful in a lot of different ways, and everything from information gathering to trying to make sure that information was equally shared with parties as they should be, and respectful of everyone's rights. So it is quite a process. It is fast moving. Ours was, because we were in and out in less than 6 months, which is fairly quick. And I think when one is deciding, is this a step we're going to take? A lot of what Alfredo's points are sort of spot on. Do you have a good business that you just need a little bit of a bridge? I think most people feel that the liquidation chapter is really just throwing in the towel. And that feels like a real failure for all the stakeholders. So people are really reluctant to do that. But if you feel like you can use a restructuring rather than a liquidation, you come around to that sort of difficult moment of pulling the trigger. I think the last thing I would say is, I imagined prior to going to bankruptcy that bankruptcy was in and of itself some sort of, I'll use the word again, failure. And what I discovered is that it's not really that. It is an opportunity to restructure, and move forward. And in fact, that is what Judge Jones said at the end of our hearing. He said, you sort of have this opportunity to pay it forward. You know, the American legal system has been good to Bristow, and Bristow has a requirement almost to take that new ability and do something good with it. Restructure the business, try to consolidate if that's what you want to do, protect your employees, protect your stakeholders. And that was a bit eye-opening for me because I'd never envisioned it that way, but it really is a second chance. It's a corporate second chance, and if done correctly, you know, can really enable a company to move forward past whatever difficulties it's facing.
Were there any things that surprised you? And at what point do you think a company needs to start thinking, yes?
Every day. Yeah, I think it's a little bit of what Alfredo said, and I think just that point where you see sometimes there's a particular triggering event, you know, that really causes you to trip your debt covenants or something like that, and your lenders have got to a point where they might have given you a number of second chances and they're just maybe not willing to do that, or, you know, sometimes there's something like that where events are sort of thrust on you and upon you. Sometimes it's just an industry sort of situation. In the helicopter business, for example, many of the major competitors had themselves been through bankruptcy. So it wasn't exactly a total surprise when that happened. It was really a lot of expansion, a lot of growth, a lot of incurrence of debt and fixed assets that just couldn't really be managed any other way. And there is a psychological, as logical as all that sounds, that you get to the point where you just don't see past the horizon. There is definitely an emotional component to it because it's a big step. And I would describe it for people that are sort of thinking about what does that mean for me? The minute that you file, chaos breaks loose. It's crazy. And you've got a lot of different competing interests. So you want to be mentally as well as sort of legal and financially prepared. You will be on call all the time to give information, to help facilitate, to help. And you need to be ready for that. And everybody needs to be ready for that. And really, it is a project and a transaction and a journey. It is not an end, which is maybe what I wasn't totally envisioning. It's actually just the beginning of a whole other process to get you out and get you going.
Hey, Mark, can I add to what Victoria is saying?
This is Gary Kennedy, the former General Counsel of American Airlines. Took it through Chapter 11 back in 2012 through 2014, right?
Right, that's right. No, what Victoria said is so accurate. And one of the concerns I think that companies have is, you know, when is that inflection point? When do you file? And, one of the concerns I have, I think, for companies and what boards need to think about is waiting too long. Because if you wait too long and assets continue to diminish, then you're harming the company. But as Victoria says, one of the concerns is that psychological jump into bankruptcy. It's a huge change and one which drives, as she said, as chaos. And so you're reluctant to do that, but you have that obligation to figure out, okay, when do I need to go in? And my view would be, if you're concerned about that or wondering, then get in, because I think waiting too long can be a big mistake.
So when you actually looked at bankruptcy years before you actually end up filing. I think and Gary, by the way, wrote an amazing book where he documents his what he calls 12 years of turbulence. That's the name of the book. It's a tremendous book, walking through his 12 years as GC at American Airlines. You had actually been almost filed several years earlier.
That's right. After the events of 9/11, we came very close in 2003 to filing, so much so that we were basically with Alfredo and his team at Weil on the courthouse steps, and were able to pull back as a result of a consensual deal we reached with our union groups. But then in 2011, after again of years and years of struggling, we had to file. And one of the concerns I had all along was we are simply waiting too long. We had a CEO in place at that time who was almost morally, religiously opposed to bankruptcy. And so we did, in fact, I think, wait too long and should have gone through the process much earlier. And
he resigned, actually, I think the day before you filed, correct?
Yeah, that's right. He simply didn't want to be part of that process. And now the restructuring turned out well, but in my view, again, we should have done it earlier.
And American was losing how much money going into the Chapter 11?
Oh, we were losing, billions of dollars, to the point that as we got closer to filing, one of the concerns we had was, as we would leverage assets, we and our outside advisors kept saying, well, what is going to be left for debtor in possession financing? Because you guys are leveraging everything. And finally, what we realized is we in effect did a pre-dip in advance because we cobbled together a package of assets and cash, leveraged everything. But when we went in, we didn't have debtor in possession financing because we had the cash we had. We had sold anything, any stick of furniture, aircraft engines, headquarters buildings, everything was gone. And so we only had the cash we had. And it was a difficult period of time to make sure that we had enough to get through.
Before I go to Andy, so with American, with you go into bankruptcy, you file in the Southern District of New York, and we'll come back to that in a minute, the venue. But you go in and you kind of have a pre-plan, but that gets tossed out pretty quickly, right?
Yeah, I think one of the biggest issues in bankruptcy is if you think you have a plan, well, with certain exceptions, but with us, you think you know how that bankruptcy proceeding is going to go along. And for us, it all went south. It all went in a completely different direction, from having a very contentious creditors committee who got so heavily involved and had an agenda, and so much so that a third party, US Air, wanted to merge with us in bankruptcy. We initially opposed that. And at the end of the day, it finally worked out, but nothing went as planned during the first, like 9 months to 12 months of the bankruptcy. And it was a big mess. And we were able to resurrect it, but it was difficult.
And then you get the deal with US Air done, and then the Department of Justice decides to weigh in.
That's right. One of the things I told my board was that if we were able to structure a merger inside of bankruptcy with another airline, in this case, US Air, that we would be able to achieve regulatory approval without difficulty. And I was completely wrong because the United States government decided to sue us to enjoin the merger. And so as close as we got, we were basically at the 11th and a half hour, then everything took a big step backwards. So much so that we thought, okay, this deal is not going to happen. And how do we then keep this company operating and keep it moving forward if we don't even know whether the merger is going to occur? And so finally, after fighting with the government for many months, we were able to resolve that through a settlement and close the deal, and ended up being an extremely successful bankruptcy at the end of the day, but it was touch and go the entire time.
And you mentioned that it was successful at the end of the day. Actually, it is considered one of the most successful restructurings in corporate bankruptcy history, is it not?
Yes, we were able to take the power of the restructuring in bankruptcy along with the value that we got from the US Air merger, and to such an extent that creditors were paid 100 cents on the dollar, including interest, and secured creditors, of course, they got what they were due. And then shareholders, which are typically, oftentimes wiped out in a bankruptcy, they received over $10 billion of new value. So everyone was happy at the end of the bankruptcy proceeding. And in fact, employees got pay increases as well. So it all turned out pretty well. Very good.
Andy Wright. Andy, longtime friend as well. Andy was the general counsel of Energy Future Holdings. First, he was the deputy general counsel, and then GC, now at Talent Energy in Houston. But Andy, you saw bankruptcy coming just like Gary did. You filed in April 2014, correct?
Yes. Yeah, we had a fundamental, the business premise at EFH was really based on the price of natural gas. That there was a deal done in 2007. It was the biggest LBO and still is the biggest leveraged buyout in U.S. history, over $45 billion. We were taken private as the former TXU. And the fundamental business premise that LBO was based on was that natural gas, which at the time was trading at $5 or $6 a BCF, would go slightly up to 7 or 8, and the equity sponsors would make a lot of money. Well, unfortunately, in 2008, we had the economic collapse, which drove down the demand for natural gas. But at the same time, we had the fracking revolution, which brought about a oversupply, and we continue to have it today, of natural gas in the U.S. It's a good thing for consumers, not so good if you're betting on the price of natural gas to go up. And so there was a fundamental shift underlying the commodity business that sort of underpinned what EFH was all about. And so the good part was that the financial sponsors had put on a number of hedges, which in a sense artificially kept the price of natural gas that we were being paid at EFH at $7 or $8 when it had actually in actuality had gone down to $2 or $3 and where it remains even today. So we saw that if by the time that the financial hedges rolled off, if there wasn't a fundamental shift in the natural gas markets, that we were likely going to end up in bankruptcy. And so, interestingly, we engaged Kirkland and Ellis was our primary counsel. We had engaged them a couple of years before we filed bankruptcy, which I think is somewhat unusual. It sounds like Gary had somewhat a similar pattern, but I think I do think that's somewhat unusual. So we saw it coming. We were as prepared as we could be, but as Gary said, as soon as you file, everything breaks loose and just your best laid plans end up not going the way that you expect it to. I thought I might say something, Victoria, when she was talking about what it feels like to be a GC or an in-house lawyer in the middle of bankruptcy. I think there's a couple of things that come to mind to me. Victoria mentioned that bankruptcy is a business deal. I used to say it's cloaked in litigation. There is an underlying business deal that has to be cut among the creditor groups and the various other stakeholders. But it's all wrapped in litigation in which the court has to approve it. So I found it as an in-house lawyer being in bankruptcy really professionally interesting because my background is an M&A lawyer, but so I got to practice those M&A skills in slightly a different context. And then I also got to see the litigation part of it all, which although we were in bankruptcy for almost 4 years, it seemed like forever at the time, many of the things that happened in the litigation context in front of the bankruptcy judge went very quickly as compared to kind of traditional commercial litigation, which can go on for years and years and years. You can have a discovery trial and a result from the bankruptcy judge in 6 weeks on big multi-billion-dollar issues. And that part of it was fun too, from my perspective. And then as Gary alluded to, and certainly the case in our bankruptcy, there was a lot of regulatory, not so much with the DOJ for us. We fought a lot of battles with the Public Utility Commission here in Texas. And that was a very difficult process that we had to go through, and especially selling Encore, our transmission business. But I think the other part that as a in-house lawyer that you have to and representing the debtor that I found interesting and not something that was part of kind of my comfort zone. At the end of the day, you're, as the debtor's counsel, you are the honest broker, I guess, for lack of a better word. You're sort of sitting in the middle. And whether one creditor group or a shareholder group or a regulatory group was the winner at the end of the day, it wasn't, from my perspective, I didn't really care who won. I just wanted to try to get everybody at the table and, in a consensual way that we could get a resolution. You got to have a very thick skin because lots of folks are going to be lobbying things into you that you're the bad guy because you're the honest broker. It's sort of like Victoria said, Congress is a good example. No one's going to get everything they want. And so that means everybody walks away a little disappointed, and that's probably the best result, quite honestly, because at the end of the day, your job as GC or an in-house counsel of a bankrupt company, is to maximize value for the entire enterprise, for all the stakeholders. And if you kind of keep that in mind and do the right thing, it's pretty simple, and have a thick skin, you'll survive. You'll get through it.
And with you, Andy, you had a couple of major multi-billion-dollar deals within the bankruptcy. You mentioned first you had the spinoff of the TXU properties, correct?
Yes, we spun off what's now called Vistra Energy. Folks may be aware of that. They're a large company based in Dallas still that is a gentailer is what they call themselves today. They generate electricity. They own a lot of power plants now all over the country. And they also own TXU Energy, which a number of you may buy your electricity from a retail electric provider who sells electricity throughout the state of Texas. That's now called Vista Energy. It was spun off to the creditor group on that side of the house. And then we had a completely separate business, Encore, that is the poles and wires business. It's similar to CenterPoint here in Houston. It's the distribution business. It's what transports those electrons from the power plant to your house or your business. We ended up selling that to Semper Energy, which is based in California, but that was what was the sort of crown jewel, arguably, of EFH, was the most difficult thing to sell. We tried to sell it 5 times, ran into many different hurdles. Warren Buffett was in the middle of it, Berkshire Hathaway. We couldn't get that deal done, and eventually ended up with Semper Energy. It was quite a journey.
Right. Very
I
good.
just wanted to try to jump in on a topic that just follows up on what we've been talking about, which is this. When one is getting ready to go in, we're focused a little bit so far on domestic aspects of the business and what it means. And I would say most people in the United States and the corporate world at least have heard of Chapter 11 and understand it as a restructuring. If for those that may be considering this move that have international operations, and as an example, Bristow had a major contract with the UK government, people outside the United States are not as familiar with Chapter 11 and immediately assume that once there is a filing or once one is in that process, that all operations have stopped, because that is what happens in other jurisdictions. And we found that as a sort of interesting avenue to prep. We had a whole separate sort of line of communication with the international operations. And of course, the international subsidiaries were not debtors. They were not part of the filing, and that engendered a lot of discussion. Why did you pick, who went in, and how that worked? And that was a little bit of some of the peculiarities of the subsidiary and capitalization structure of Bristow itself, which comes out of who runs an aircraft operating certificate and some very technical aspects of the helicopter business. But I did find that somewhat interesting that, and for everybody, for the Bristow employees, for the customers, for the vendors outside the United States, they literally assumed that everything was going to just stop at filing. There was a whole communication plan to say, no, that's actually not the case. Please don't stop contracting with us. Please don't undermine the purpose of the business, because really we're trying to get out, and it's a restructuring. And it is something that I think people ought to be aware of, just how it is perceived, especially as how busy you are in bankruptcy. Something to remember, the PR plan, the communication plan, and how people are experiencing it and perceiving it differently. The Bristow group just said, nobody else worry about bankruptcy except HQ. We've got this, you don't need to worry about it. Your life goes on as normal. And I hope that was fairly effective, but I know it did not feel that way for many people outside the United States, including random stakeholders such as pension trustees for pensions outside the United States. So we saw a lot of that communication piece from different perspectives was somewhat important in getting us through to a good result.
Gary, you have American had operations all over the world? Similar kind of issues?
Yes, we did. We put everything that we could, put into the jurisdiction of the bankruptcy court into bankruptcy, so all of our subs. But we also had issues when we had aircraft located in foreign jurisdictions, and for example, they didn't do what they were supposed to do. Fuel a plane, for example. In one case, we did have someone who, and this happened to be ExxonMobil, who refused to fuel the plane, located in a foreign country. And of course, we immediately got back to Exxon and said, no, you can't do that. And they fixed the problem. But yeah, that was a similar problem for us as well.
You actually called Jack Malaysia, the general counsel of Exxon, yourself.
That's right. I said, hey, Jack, you know the rules here. And so it didn't take too long. We got it fixed that same day.
Right. Let's go backwards. Gary, you filed first. Why did you pick the Southern District? Let's talk about venue. What were the decisions, and would you do it the same way today? You went to the Southern District of New York. Yeah, interesting. And I don't know, and I'd be interested in Alfredo's input here as well, that with COVID, and assuming that COVID's going to go away, but today with COVID, I think the venue decisions may change, because if you're remotely in court as opposed to in person, at least some of the things that we thought about may not have had the same impact. But determining venue is an extremely difficult decision. Venue provisions of the Bankruptcy Code are very broad, so you can sort of almost file where you want to file.
We set up a subsidiary in New York for the express purpose, really, of being able to file there. And the decision for us came down to either the Southern District of New York or here in North Texas. And we had the same question back in 2003, and again when we actually filed in 2011. And initially, I really pushed for and believed that we should be in our hometown, file in Fort Worth or in Dallas. And I know that our outside advisors really believed that we were better set in New York. And so we went back and forth on that question. And, there's a myriad of issues here, and I'll just name a few of them. But one of them, the question is, does a debtor want to be in its hometown, perhaps getting what I would call a little bit of hometown advantage with a community and perhaps even a judicial system that is highly focused on the restructuring of that business that it succeeds, versus the question of, do you really want, and in our case, 10,000 employees marching on the courthouse steps, protesting whether it's executive compensation or the direction of the company. And so that is also consideration. I will say that it was much more difficult for our employees to go down to the bankruptcy court, in Manhattan to show up to picket. Now they did, but the numbers were much, much smaller than they would otherwise have been. So that's I think that's one of the considerations that we had, although I always felt that we were kind of running away from our problems rather than facing them. And, to bottom line your question, if I had to do it again for the convenience both of the management team, and also a little bit this question of, kind of who's a little bit kind of controlling the bankruptcy. Do your creditors and your outside counsel and others kind of make their way into the Dallas, Fort Worth area rather than us traveling in mass to New York all the time? And it's a tough sort of balance. But ultimately, and I can say this now because in retrospect, I wish we had filed, here in the Dallas Fort Worth area.
Now, you also filed in the Southern District because everyone said, oh, the judges in the Southern District, the bankruptcy judges, have so much more experience in handling such large, complex Chapter 11s. And then you file and you get what?
Yeah, we file, we get a judge who is brand new to the bench, Judge Sean Lane. And the first thing I remember saying to my wild friends was, what the heck? What is going on here? We've got the brand new guy who's never handled a case of this magnitude. But I say this now, and I said it, earlier, but once Judge Lane opened his mouth and started talking, I had a real sense of relief that this guy he's going to work out well. And in fact, he was so good and so meticulous through our bankruptcy process. But it did not turn out exactly. We didn't get that long heralded guy with a person with a lot of experience.
Andy, you next. Why did EFH pick Delaware?
Well, I think at the end of the day, we picked it because our restructuring is a little bit different than Gary's, where his was focused a lot on unions and the people that were sort of based and arguably based in Texas. But ours was more of a financial restructuring. It really wasn't an operational restructuring. The underlying business was not flawed. We were just over levered. We had $40 billion of debt that we couldn't pay the interest on. And most of the parties that we were dealing with were creditors, and they were New York based. We did not have a New York presence at all, and so that really wasn't an option for us. And so we were a Delaware corporation, and so the natural next step was Delaware. We were convinced by our outside lawyers at Kirkland that certainly the Delaware bench could handle a bankruptcy of this size. It ended up the fifth or sixth largest bankruptcy in U.S. history, and our judge, Chris Sanchi, did an excellent job. I suspect that it will be the biggest bankruptcy case that I know it was the biggest case that he'd ever had and probably will have even for the rest of his career. I thought, as Gary said, from the very first moment, he kind of took control of the case. And while I didn't agree with every single one of his rulings, he did the right thing. And I think we as a management team in particular, and a couple of our board members, the independent board members, I think developed over the 4 years of working with him a very good rapport. And I think that's very important from whether it's the GC. I know I had to testify a handful of times. Stacy Doré, our former GC, also had to. We were deposed a number of times, which is an unusual position for an in-house lawyer to be up on the stand and actually answering questions. Now looking back, it's an experience that I'm glad I have. I don't know if I want to do a lot more of it in the future. I think one other thing that had we known, and it's something that you just, unless the law has been well settled in a couple of areas, I think had we known what eventually, there was a couple of multi-billion-dollar disputes among the creditor groups in our bankruptcy. They had to do with what was called make-whole provisions in our debt documents or our indentures. It ended up that Sanchi ruled a certain way, which was consistent with the way we had thought that the indenture should be interpreted. It ended up going to the Third Circuit. This was all during the 4 years of our bankruptcy. The Third Circuit overturned that decision, went against what the rule was in the Second Circuit and what is in the Fifth Circuit. I think had we known that the Third Circuit would have ended up ruling the way they did on a couple of really key issues in the bankruptcy, that our creditor groups would have almost insisted that we filed in Texas. It would have had nothing to do with hometown or anything else. It was just what the rule of the law was in the jurisdiction in which we filed. And so that is also another consideration. It generally isn't the primary consideration, but at least something that you and your outside counsel need, and they will do a kind of a survey of what are likely to be kind of the key issues in the bankruptcy. And if there is a difference between the Fifth Circuit, the Third Circuit, the Second Circuit, the Ninth Circuit, that may dictate a bit where you end up as well.
Right. I want to go to Victoria and then to Alfredo. When Gary and Andy were filing, the Southern District of Texas did not have its new rules in place. They did by 2015, 2016. Victoria, why did you choose to go into the Southern District, and what did you think of the rules there? And then Alfredo, you follow with that.
Yeah, I think a lot of what Gary and Andy alluded to was sort of spot on, and perhaps the difference was that the Southern District was a little bit more developed, if you want to say, with different rules. Certainly convenience was a factor. And it was thought in the Bristow bankruptcy that there was a particular plan going in. There was a restructuring support agreement filed at the time of filing. That is not the scheme and the transaction that ultimately brought the company out of emergence. So not totally unusual. What you thought going in was not what happened coming out. But it was thought to be sort of an agreement, something that was going to be in and out quickly. It didn't quite turn out that way. But I think our experience was just that we were in Judge Jones's court. He was schooled both in the business world and in the legal world. I believe he has an MBA. Mark, you might be more current on the credentials, but certainly very, very business savvy, very, I would say debtor friendly in the sense of if it made sense for the company, he wasn't going to try to just on his own try to undo agreements that had been done if the company seemed copacetic with it. We did have business people testify. And I think, Andy, you mentioned testifying and being deposed. It's not so much fun for a lawyer. It's so scary for the business people. And our witnesses did phenomenally well. The judge was very kind and very appreciative that business people actually came to court, and was very respectful of what the company was trying to do, as you said, Andy, the honest broker, the one in the middle that was sort of spectating between all the different creditors and trying to get the best outcome. And so I think the reputation of the Southern District is now such that it is a viable forum. I think it always was, but it certainly has a great reputation now, as your charts and your information shows. And we don't, unless they sort of fill up, it's probably a reasonable alternative for anybody else that might have thought before, I need to go to Delaware, which we could have done, or New York or something else. And I'm curious to see if it just kind of in legal geekiness, if you want to say it that way, is it going to be sort of like the IP dockets, the rocket dockets on the IP side, or other sort of special jurisdictions that have developed a reputation for handling things efficiently and effectively, because I think the last point on this is cost, and the dollar amounts that are spent in bankruptcy are enormous. And if there is a way for a company to make that more efficient and more effective, people are very much open to that and appreciative of that.
And before I go to Alfredo, if you haven't, I wrote a profile of Victoria right after she finished the GE Baker Hughes deal, and you want to talk about someone who's strategic. She actually structured the deal so that GE could very easily take it apart, right, if they needed to. And lo and behold, within less than about a year, they didn't need to do that. So Victoria is very strategic in her planning. Alfredo, kind of, what do you advise clients on where to file for venue, and then talk to us a little about how the Southern District of Texas has evolved?
Yeah, so as Andy indicated, there are significant changes in the law between the various circuits. Probably the most significant, other than the make-whole, which is frankly still evolving, which is a huge dollar issue. Probably the other most significant issue is the treatment of intellectual property, whether you have the actual test or the hypothetical test. If you're trying to enforce an intellectual property agreement, you really want to be in the First Circuit, Second Circuit, or the Fifth Circuit. You don't want to be in Delaware. So there are differences in terms of the test. I think everything else really, a lot of it depends on convenience of the parties, and kind of what people have seen. There was a one of the big issues recently was the covenants running with the land. That got a lot of play. There was one case in New York in which basically the bankruptcy judge, threw out the covenants running with the land. I think that was finally litigated in the Alta Mesa case in Kingfisher, where Judge Isger actually enforced it. So there are a couple of issues like that you're seeing. So there are differences, and obviously that should be a consideration. Obviously, the other one is cost, and the kind of the friction costs as well as the actual costs of the bankruptcy. And in terms of the Southern District of Texas, I've been practicing for a long time, and I think some people will recall that Delaware wasn't a bankruptcy venue until the second Continental Airlines case, when the first Continental Airlines case was still pending in Houston, and Judge Wheelis decided he didn't want to take the second Continental case. So that's literally when Delaware became a venue. And in terms of the local rules here, there have been from time to time local rules, and Houston has been a very active docket. Certainly was in the mid 80s. They had M-Bank and Global Marine. I mean, just a lot of cases. I think in the early 2000s, the oil and gas business was just booming, and so you really didn't have much. So I think that when Judge Isger, who came on in 2004, and then when Judge Jones joined him, I believe in 2010, they really put a lot of energy into making the venue more user-friendly, in part because of the technology, so you didn't have to come down here for a 15-minute hearing. And I do think that they've got input from all firms. So when you look at the local rules committee down here, it has lawyers from firms all over the country, to really make it as safe, as efficient and as user-friendly as possible. And I do think that people believe that, unlike a lot of other courts, there is significant accessibility here that may not exist in other courts. I mean, I think both the Southern District of New York and Delaware pride themselves in having accessibility to the courts. I actually think that the Southern District of Texas does a wonderful job with that, and really nobody's ever going to say that. Nobody's ever going to say that they couldn't get a hearing, and that's the reason why the case ended up that way. I think that's been very, very, very helpful.
Yeah, that was certainly our experience. Alfredo, you're absolutely spot on. If we needed to get to court, we were able to get there, and that was very important for the company.
Right. No, that's it. I mean, Judge Jones told me he's held hearings on Saturday mornings, Sunday evenings, etc. He's got a full-time clerk that has a cell phone that he answers 24 hours a day. So accessibility is very important, obviously, and predictability, right? Consistency, predictability. And within the Southern District, you have just 2 judges, Isger and Jones, who handle all the complex cases. And as the Lawbook reported last week, is that those 2 judges now handle more complex business bankruptcies of $300 million or more than any other court in the country, any other district in the country. So obviously it's been successful. Let's start with Alfredo and go backwards. Alfredo, why are bankruptcy so expensive? I once quoted Gary Kennedy as saying, bankruptcy is becoming so expensive, you just can't afford to go bankrupt anymore. What are the issues there, and how do you advise companies to keep down the cost? Alfredo? We may have lost.
Okay. Yeah. Can you hear me now? Yeah. Sorry. Just imagine if every business transaction that you did, buying a piece of equipment, selling a piece of equipment, entering into a contract with a new employee. Just imagine if every single one of those transactions had to be litigated and had to go through court. And I really think that the cost of the bankruptcy are really related to the fact that you've overlaid a legal construct on your ordinary garden variety business transaction. So the company doesn't stop working, but you've overlaid that. So I think that's number one. Number two, unlike a situation where, the company makes a decision and goes implement the decision in a bankruptcy, because of the fact that you're in essence a fiduciary for your creditors, whether you like it or not, there's a lot of other people who have a say in what you do, and their motivation may be completely different. I mean, one of the interesting things that happened recently, there's a provision in the bankruptcy code which says that if you represent a group of creditors, you have to file a statement saying kind of what they own. And so oftentimes you'll be negotiating with a creditor who you think wants one result, but because of they sold some, credit default swaps, or they have a hedge, or they have something else like that, really they want the opposite result because that's what will get them the most money. Or you're negotiating with a creditor who may have, maybe in 1 or 2 or 3 parts of the capital structure, and it's really unclear to you where they really want to be. So you have a situation where the path to a decision is not linear by any stretch of the imagination. You've got all these other influences. So that's, I think, the second point. And then I think the third point is, the fact that once you're in this process, unfortunately, people have to do something, because if you've got a client in the process, what are you going to do? Just, that's okay, it's not a problem. People just feel compelled to give you their 2 cents, whether there are 2 cents to give or not. Maybe there's a half a cent to give it, but they still give you your 2 cents. So you've got you've got litigation overlay. You've got this funky process where you got to go to 86 people. And of course, if you went, I question whether, if rather than trying to get consensus and everything built in, whether if you went to the judge every time and let the judge decide, whether that would be more cost efficient. unfortunately, you may not like the result. But I mean, you got the way you make decisions, and then I think you got the fact that lawyers kind of find themselves, trying to represent a client, and those are kind of my three kind of reasons why it turns out to be as expensive as possible. And then, I mean, I can't let it go without saying that, when you are writing off $4 billion of debt or $5 billion of debt or $40 billion of debt, and the bankruptcy costs you half a billion, I mean, would you have paid that amount to get rid of it? I don't know the answer to that question, okay?
Gary, let me go to Victoria, then Gary, then Andy. All three of you as GCs hired, look, there's the two most prominent bankruptcy firms in the country, Weil, Godshall, and Kirkland & Ellis. All three of you hired those two firms. I guess number one for Victoria, how did you pick outside counsel? And number two is kind of talk about what you saw as the expense of it.
Yeah, I'll just jump in quickly. So just a quick point. During the bankruptcy, Bristow was represented by traditional company counsel, which were a combination of Wachtell and Baker Botts. And so the choice to use the continuing counsel was probably obvious, knew the most about the company, had a long history, and were able to be brought in significantly earlier to help with the planning. And I will say one thing for people, that there are certain press releases that one puts out when one is required to hire advisors. And there are certain advisors that operate in the space, including two that we used, Houlihan and Alvarez and Marsal. And perhaps it is colloquial wisdom now, but if you put out a press release that says the company has hired Houlihan and Alvarez and Marsal to discuss strategic options, I think most people know what that means. And so you have to be a little bit careful about, you've got to disclose the information, but oftentimes if you do have company counsel that are well schooled in this area, it's a huge advantage to have them in early, because you're evaluating options and it means something different than if you've hired a traditional restructuring advisor. You are correct, Mark, that Kirkland represented the largest portion of the unsecureds that ended up becoming the group of majority shareholders in the company. And Kirkland was our outside counsel for the subsequent merger. So basically a week after emergence, the company began discussions with the Era Group and then consummated the merger in June. So that is accurate. But I think the other aspect, had we not gone with the company counsel, certainly people that have an excellent reputation, Weil is one of those firms, Kirkland, there's a number, and you alluded to them, it's always important because it is such a technical process that even if you know M&A or litigation, you don't know bankruptcy. And it is super important, whether you're an individual trying to file for bankruptcy or you're a massive corporate creditor, there are a lot of pitfalls, a lot of deadlines. I didn't know that there were special deadlines for liens on aircraft. I mean, why would I know that? And there are. And so a good technical advisor is very, very important. As for the financial advisors, again, there's sort of a group that hovers around the space. And so people tend to look at the same, people who have a lot of experience. We found industry experience to be helpful. And I think the last thing I would say is the appropriate culture of aggressive enough to defend the company and its stakeholders, but savvy enough to be able to cut a deal. And if necessary, march into court and defend that in front of the judge. And so those are, those people don't just fall off the truck. They really requires good experience and good capability to be able to bring all those to bear.
We've got about 12 minutes left. Gary, I remember when I first wrote the first story on your fees, and of course, you also had a very expensive firm on the other side with the creditors that got appointed for the first time ever representing creditors, but you were spending about $550,000 a day in the bankruptcy. First, how did you decide on counsel, not just legal counsel, but the financial counsel, and then talk to us a little bit about what you were surprised on fees.
Yeah, I'll just very briefly. We had had a 25-year plus relationship with Weil Gotshal, so our decision to hire them in the bankruptcy because they had represented us in other matters was very easy. And they, as one of the premier firms in the country, it just made total sense for us to do that. One of the reasons I believe that bankruptcies are so expensive is because not only did we have, of course, Weil Gotshal, but we had a handful of other law firms that had a specialty in certain areas that had a relationship to the bankruptcy. For example, we had pension counsel, and pension counsel, they were billing us. And then we had labor counsel to handle the 1113 matters. And so we got their costs. Then, of course, as you know, the debtor pays for everyone. The party who's least able to pay pays for the unsecured creditors committee and their counsel and their specialists, their financial advisors. Then we had an ad hoc committee of creditors. And of course, we graciously offered to pay their fees. And so the fees just mount up. We even had the US trustee wanted to hire and did hire a fee examiner to examine the fees. And of course, we paid for the fees of the fee examiner. And so it's a constant wheel. And in fact, Alfredo, I submitted a invoice 6 years ago, a credit memo, and I'm still waiting to get paid on that. So anytime you want to process that, please, I'm anxious to receive it.
There you go. And Gary, I guess at the end of the day, your ticket price was what, around 300 million? Was that?
Yes, $300 million in total. Yeah, and that, of course, that included, once we got into the M&A piece of handling a merger inside of bankruptcy, and then litigation with the United States government on that whole issue. And then we had, and I had to testify twice, once with the House and once with the Senate. And so there's just all this stuff going on, and all of which is just driving fees, it felt like in perpetuity.
Right, you hired Jones Day, I believe, to do the antitrust part of it. So.
Right.
Andy, you would love to have only had to pay $300 million in fees, right?
Yeah, that seems cheap. Yeah.
Stories that I know you and I interviewed you many times. There were points where you were paying close to $800,000 a day.
Yes, and I think when you added it all up, which it also includes the financial advisor fees, the company ended up spending north of $1 billion in fees in the restructuring, which, when you stand back, is just a huge number. I mean, Alfredo was correct. We were restructuring $40 billion of debt, so $1 billion of fees in that context makes a little more sense. But it is, quite frankly, as an inside counsel, in-house counsel, it's overwhelming. I don't know Gary and Victoria's experience with this, but you literally would get stacks that there's lawyers at the firm that all they do, because these things are so scrutinized by the courts and by the other creditors. There's lawyers at Weil Gotshal, at Kirkland and Ellis, that spend their entire month preparing the bill that they're going to submit to the court to get approved. I mean, it's crazy. And this was another thing that I didn't realize, and I don't blame the law firms for it, but historically, when I hire a law firm to do work for me, they're not charging me to actually bill me. But because there are 2 or 3 junior lawyers who spend most of their time preparing the bills that actually go to you, they actually charge you to even prepare the bill to be submitted to the court. It is standard practice. And as Gary said, we didn't have a proposal. We did have a fee committee. We had another law firm who actually looked at all the law firm's bills and said that they were okay, and gave it, I don't know how many millions of dollars we paid to them, whether they ended up saving us the amount of money that they ended up charging us. I don't know. I'd like to think that they did save us some money at the end of the day, because they negotiated particularly with Kirkland, and I know Alfredo probably sees the same thing, and Weil will give some money back, and so does Kirkland, and back and forth. Another big part of it, and Gary is exactly right, is the notion that this is a transaction, and in order to get everybody ultimately to exit from Chapter 11, you need the vote of the creditors. And in order to get them on board, you end up negotiating a deal, and sort of news to me, it wasn't by the end, but at the beginning, was they said, well, I'll agree, but then I want you to pay all my professional fees. And so, okay, here comes a $50 million bill from their outside counsel, and you've had no ability at all to control anything they're doing with their outside counsel. Here, just pay and it's basically a one-line bill, pay $50 million, and that's the cost of getting them on board. So that is certainly very unusual in a normal M&A context or business context. Both sides generally pay their own legal fees. And so that is another thing I think that is certainly driving up the cost of the bankruptcy. Look, when it comes to choosing the law firm, we had not, we obviously had some deep relationships with a number of law firms around the country at EFH. But I mean, I'll be frank, the sort of size and complexity of our bankruptcy necessitated that we go to one of the very small handful of firms in the country that had kind of the arms and legs to do our deal, to do our bankruptcy. While as one, Kirkland's another, there's a couple of others around the country that truly have the arms and legs. I mean, most big firms have a bankruptcy practice, but not a huge debtor practice the way that these small firms or these larger firms in small group do. And so we interviewed a number of them. We were owned by private equity, and obviously they had a view into that. I would say now, looking back, we just interviewed the bankruptcy lawyers, and I think that's probably a wrong approach. I think there's really three key groups within the firm that you ought to talk to, not only the bankruptcy practitioners, but talk with the litigators that work with the bankruptcy folks. There will, certainly in big cases, there will be one or two fairly senior litigators that will argue most things in front of the court. Knowing who those a couple of folks will be is important. And I also think interviewing the M&A folks, that if what you end up doing is an M&A deal or deals as part of the larger restructuring, knowing who the M&A team is that's going to be representing you, I think is important. So I look, there's all kinds of other specialty regulatory. In Gary's case, he says the pension drove a lot of it. I get it. And maybe in certain instances, you ought to insist that you talk with some of those folks too. But it's a package deal. You're not just hiring the bankruptcy team. They may be kind of the hub and the spoke of the hub of the transaction or the bankruptcy, but there will be some other key contributors from the law firm that will end up really billing a significant amount of time and working very closely with you as inside counsel.
Each of you, we got 1 minute left for each of you. What does a successful bankruptcy / restructuring look like? Andy, let's start with you. What does it look like?
Well, exiting is successful when it comes right down to it, and hopefully restructuring a business in a way that it can be successful going forward. I don't know who mentioned it before, who said, the judge said, it truly is a fresh start. And there's a multitude of ways that fresh start can be. I think it's really as simple as that. It's getting that fresh start that allows the business and all of its stakeholders, and businesses have tons of stakeholders. It's not just the shareholders or the creditors, it's the employees, it's the regulators, it's the customers. I know there's a big debate going on in the business community today about whether we ought to be, working just for the shareholders or whether we're working for all of the stakeholders of the business. But the bankruptcy process, I think, at its core, is trying to find a fresh start for all of those different stakeholders while still maximizing value. And if you can find that sweet spot, you've been successful. And that sweet spot, I think Victoria mentioned it before, usually means that no one's completely happy. Everybody walks away with a little bit of a bad taste in their mouth, but you have a few good morsels in there too. And I think if you end up in that sort of position, you've probably been successful.
Gary.
Just quickly, I think it's exiting bankruptcy with the restructuring in a way that you don't have to return to the bankruptcy court. My concern with COVID and the hit on the travel industry is that the airline industry will be back in court in relatively soon, and that's unfortunate.
Victoria.
I think a bit of the same: exit efficiently, expeditiously, and exit with a business. You know, is the operations, the relationships, because the creditors are often involved in operations also. And so if you make, you know, if creditors get very irritated, but they also have equipment financing or things that the company needs to go forward, and those relationships have been poisoned, that's not a good result. So the opposite, maintaining relationships, being friendly, cordial, and basically getting out, as Andy said, is success in my book.
Alfredo, you're involved in several nationwide, from Chuck E. Cheese to so many, McDermott, et cetera. Are they all the same? Do they all have the same,
They really don't. I think the key is to maximize value for all stakeholders, the employees, the creditors, the shareholders. So I really think there's no one size fits all. And I think the goal is just to try to maximize value to the extent possible and use the tools, the bankruptcy tools, in order to be able to do that.
Very good. Well, I want to thank the panel, great discussion, incredible insights. Each and every one of you, thank you so much. Again, I want to thank Nicole and Elena of ACC for helping put this together. Without your help, we couldn't have done it. And you're welcome to reach out to any of us if you have any questions. Thank you all so much, and have the great rest of the week.
Thank you.
Thanks, Mark.
Thank you.